Oh my goodness. Here it is. I've been checking every day for the Sarah Boone novel to arrive. And alas, it's 10:30 at night. Now, it may have come sooner. I'm with family right now, so I haven't been on anything today, all day, and part of yesterday. And so it could have come on earlier today, but here it is. But it's like, okay, I can't wait though. Let's see what Sarah has to do. Say. What the heck can she be saying that is even going to matter? I really suspect a lot of this is going to be very redundant, but let's see what she has to say. So, hand delivered June 7th. Sarah Boone and the Honorable Judge Michael Cranick. Blah, 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 blah. Well, like, here's, look, here y'all do. If you want to be Sarah's pen pal, there's her address. Oh, Lord, not me. All right, so hopefully you can see this. If you can't, I'll try to read the best I can. And I will tell you right now, I'm going to probably mess up on words. She has very beautiful penmanship, but it's also very difficult for me to read, and I can't see even with glasses. So, but let's try it and see, okay? So, Honorable Judge Cranick, ongoing 5 years. Why can't I use my constitutional rights? Boy, that sounds a lot like Daryl. Am I the only one who cares about the ongoing violations of? Is that what she's saying? Lord, guys, I'm so sorry. Am I the only one who cares about the ongoing violations of? Okay, question mark. Sorry about that. Have a bond. Have all my medical records. Have all my digital evidence and discovery. Have all my paperwork, notes, letters, pictures. What pictures? The pictures you took of George and his battered, suffocating body in the suitcase. Pictures, everything of mine returned by my former attorney. Is it attorneys or attorney? Good question. Because which one could she be talking about? I don't know. Speak to my investigator. Have a complete download of my phone. Can she do that? Isn't that in evidence? I would think. Have any of my witness lists. What witnesses? I think you had a dog there, that poor dog. Give any insight, understanding, clarifications, truths about my case, especially to my attorney. Be listened to by anyone, especially my attorney. Oh, for the love. Be respected for who I am truly, especially by my attorney, and not be disrespected for the... Is that mutated? I am really sorry, guys. I apologize because it's hard for me to read. I'm going to say mutated, malicious. Oh. Is it mutated? I don't know what it is. But malicious murderer all the world has falsely, incorrectly created and believed me to be. Well, I don't know. You tell us, Sarah. You're the one who said you had a good day. You painted, you put puzzles together, and then you said, oh, let's play hide and go seek. George, you get in the suitcase, and I'm going to zip you up. And then probably, I still think somehow she threw it down the stairs or something because his head had injuries on it. And, you know, left you and have it on recording. You tell us, Sarah, what are we supposed to believe? Okay. Be treated fairly, lawfully, and be protected by the justice system. Properly, rightfully, completely defend myself. See all and know the same as the world can. And oh my gosh. And we're on page 2. We only have 57 more to go. Okay, sorry. And does, including my attorney, from all the phenomenal. I am sorry. It's late, and I know I'm probably mispronouncing it. But you know what? I mean, I love her big words. But you know what, Sarah? We really don't care. We know that you had all these in middle school, but we really don't care. Non-permissive amount of my entire case being available on the online globally before my trial, and most important, before I have seen myself. What doesn't anyone know already about my case? Well, you tell us. How about my side and everything about everything? Be correctly understood that I am not the problem for reasons. I am not the problem, please. For reasons I am on my appointed by the court attorney number 8. See my letter 7/21/23. Say what I want and should, but all the world can say it all wrong and warped. Why won't my attorney give me an honest answer? Okay, I'm going to stop right up there. Okay, I think this is hilarious because she thought she was all smug and clever to deliver that 48-page letter. Yeah, she delivered it that day in court, but Miss Patricia Cashman already submitted her motion to withdraw. She kind of beat you to the punch. I mean, you criticized her horribly, and now you're just sitting there complaining about somebody that is already trying to exit. Hopefully the judge will let her. This is hilarious. Okay. Give me an honest answer. Show me everything she says she has and finish reviewing for my case, but withhold from me after I ask repeatedly for and about. Give mean answer other than I'm putting this to rest. Oh, give me an answer other than I'm putting this to rest. That's not necessary, or I'm not having this conversation with you. Grant me access to anything I ask for in and about my case. Like the detectives in my case. Stop putting words in my mouth? That's a question mark. You know, she went over a bunch of this stuff. Like she's talking to the judge about a bond. Oh, you are not getting a bond, Sarah. Tell me what's going on in my case. It's been well over 100 days. She has been my attorney, and I still do not know. Ongoing. 5 years. Answer any of my questions. Because they're probably stupid and they're not necessary, and she's trying to tell you what's going to work for you, hopefully, and you're not listening. That's what's wrong with you. How can she supposedly know everything she needs to know from what she's been told, heard, read, seen. Reassure she's on my side, for me, not against. Well, I'm sure that she tried to do that, but I get the feeling that Patricia Cashman is somebody that just doesn't play. There is nothing wrong with that. The time is ticking, and you've had 7 attorneys to ask these questions, and it sounds like it's the same stuff, and I think some of that stuff they just can't do. You didn't study law, Sarah. They did, and they know what they're doing. She is a freak. Why have I already been judged in the court of public opinion? How did that happen? Let me just tell you, this one is a no-brainer, Sarah. It happened when you decided again to zip George in a suitcase, record him. He's gasping for air. You can see, his figure moving in the suitcase, saying, begging, pleading, Sarah, please let me out. Sarah, I can't breathe. And she's saying, well, that's how I feel when you cheat on me. That's how I feel when you choke me. You just need to you just need to shut the F up. Yep, that's my name. Don't wear it out. And then she goes upstairs, and it was on accident. It wasn't intentional. What does she expect? She has laid out the whole case for us. I don't even know why the heck she's taking it to court. Anyhow, I digress. Because that is how it happened. And you are an idiot. Why have I been sentenced by anticipation and condemned before my predicted trial? Probably because you're acting like a big know-it-all Karen. Why does my attorney and all the world think my case is already over? Well, it's not going to be over as long as you continue on. I'll probably have to get my grandchildren. Well, I'll have to pass it on to my grandchildren. Well, I'm not that much older. Well, a bit older, but my children, they'll have to, pick up where I left off to see what attorney you're on. You're probably on number 101 by then. Why does my attorney and all the world think my case is already over? Well, Your Honor, during our first introduction at my last withdrawal of court-appointed attorney, number 7, Mr. Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters as conduitely, did I say it right? As conduitely or conducively? I can't read it right. Anyhow, I'm so sorry. They are to the world where all my potential jurors are located, and this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantage, hindrance, impediments. I don't even want to try to pronounce it right. She's irritating me the hell out of me. I am still experiencing on the top of the new oh my gosh, I'm so sorry. I'm going to have to pause and try to read that word. Sorry. I'm sorry. I still can't get it. If you want to, you can pause it and read the words, but her writing is hard and this is very rough, but I just figured at least you'll get the gist of it. I mean, probably she could have made it 5 pages tops, and it would have been fine because it's the same stuff. Okay, so the race to the pulpit is unfair And it is important to me that you are aware and understand what transpires when the news cameras are off and we're all in between my status hearings. 2, as so many of the advantageous embezzlers, racketeers, oh my gosh, mindless, what is she writing? Lemmin? I don't even know. I can't, I usually can read her words better, but I'm going to skip it. And just altogether, mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people and being said incredibly incorrectly. So can I. Oh my gosh. I'm telling you, I mean, she writes, she's very wordy, all that, yes, we know, but she sounds like middle school. This sounds like middle school talk. Let me see. Oh my gosh. Pick up to as the compelling, annoyed detectives in my case, I don't know what that name says. Somebody had to falsify documents and Lowen, I guess the name, wore his gun for me to see. I am sure you are familiar with after watching all my plastered, highly misconstrued, over 30 million views just on one side. She's counting. She kind of likes it. Don't let her fool you. Interviews, and in which they both repeatedly attempted to feed me their incorrect, incomplete, hypothesized opinion by stating to me everyone has their limits at this seemingly endless point of perpetuality of nonsense and lawlessness still growing. And, okay, we're on page 5. We're really making headway here. And I very much want to advance to the next level after ongoing 5 years now. A genuine concerned limit has been reached. Why am I still not being included in my case? What the hell is she talking about? She was sitting there in the court the other day with her 58-page stupid letter. I don't know how much what does she want to do? She just needs to defend herself, and that's going to make me nuts too, but this is ridiculous. Okay, why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose to the internet? That's right, as I'm reading it right now. Because you know that when you do it, it's getting out there. So don't act like, if you don't want us to read it, then don't put it there. Because it's public, it's public knowledge. So here we go. Okay, it gets loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial. Anything fair, my side foremost, and wondering now if my attorney drank the punch like everyone else. Well, I mean, she is so insulting. I don't know how she does not get that. I'm sorry, but I think Patricia, Miss Patricia has said, see you later, Sarah. I mean, this is so insulting. Nobody's going to want to do this. Nobody. Okay. All aforementioned reasons and so many more for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing of corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the what and shock? Is that what she's saying? Oh my gosh. Anyone fearlessly challenging the status quo, and it must be so because it's in my face on the computer at the same time on my boob tube. Oh, Sarah. Well, don't look at it then. Television, brainwashed, ignorant follows of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seem worse than theirs. No, two, when anyone points their finger, one, she did not really say it's impolite. Really? And two, 3 point back at you. No, not me. I have a closed fist and I just use my index finger, so none of them will ever point back at me, Sarah. How many tried it to see? Huh? Nope. Mine, nope. When I'm pointing at you, my fingers are like this. Nothing's pointing back at me, so, Nice try. Okay, we're on 6. And again, I do apologize, but I figure we'll still get the gist of it, even though I cannot. And like I said, you can always pause it and probably see the words better than me. Put the stone down, as there will be no casting of anything today, except maybe for the role of my part, for all the pre-conclusioned documentaries. Have they been documentaries? I don't know if I've seen any of those yet. And crystal ball, real life stories of the true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened, and is going to futuristically remember. Going to futuristically, is that what it's saying? Oh my gosh. Remember 3 point back. Nope, I'm telling you, if you point it like this, well, they're pointing back, but I'm covering them up in my fist. So, shut up, Sarah. To sum it up, in the words of my attorney after I told her to Google me, she stated, there's a lot. Well, apparently you've been Googling yourself. Come on. Sarah's an attention whore. Don't tell me she's not enjoying some of this. All of it. To sum it up in the words of, okay, she said there's a lot. To sum it up in the words of myself, the defendant, sorry, I'm sitting there putting my hand all up there, stated to my attorney after she stated that to me, when can I see, how much longer do I have to wait, or how many attorneys must be withdrawn for me to be included in my case? I don't know. I feel like you have really included yourself just fine, and be included more than the world presently is. Well, this is my case in every aspect. See all my aforementioned ongoing 5-year questions I am still waiting on for answers. I think you're not asking the right questions. And probably you have said so much you just need to shut the fuck up and let somebody tell you what you need to do to save yourself. I mean, sorry, let me move this down. Okay. Also, I want to make it known I walked out on my attorney. Oh, that's good. Let's see how come she walked out on the poor Miss Cashman in our last meeting due to her unwarranted, uninformative, unprofessional, snotty, there she goes again, attitude, and her untruthful answers to my questions and beyond. She didn't write the retarded vicious cycle, did she? Is that retarded? No, Sarah, you can't be saying that. Am I reading that wrong? Does that look like that says the retarded vicious circle? We enter every time we meet is a waste of time, and I'm saying that being in jail with supposed endless amounts of how she treats me is extremely prejudiced, hostile, and unconcerned. Look, I'm telling you, I've heard other attorneys speak of Patricia Cashman, and they said she's very good. But you know what? She's not going to coddle Sarah. She's not going to baby her, which she really does not need at this point. She needs what Patricia's doing. So she writes, she is very frustrating. Like you. Number 1, to balk or defeat in an endeavor. To induce feelings of insecurity, discouragement, or dissatisfaction. 3, to bring nothing. Right down there. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condensation. Oh my, pretend judge, and so she could calm down? Oh my gosh, you were so delusional, Sarah. Offensive demeanor and obvious prejudgment. She seems like everyone else, not to remember I am innocent until judged otherwise. She treats me as if I am not. Well, I hate to say it, but I can say this because I am not an attorney or a psychologist. I am just some psychologist, psychiatrist. I am somebody who's reading it just like everybody else. And we're not all as stupid as you think we all are. And you're being an idiot. It's you. Yes, to bring nothing. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions. So she could, I already read that part. I'm sorry. It's probably just as well. What pretend judge? She's telling her to pretend. Sorry about that. To pretend. Oh my goodness. Pretend judge. What the hell, Sarah, are you talking about? She's getting me all worked up, and we're not even to page 10 yet. I'm getting like, I've got the fan going. Okay. Pretend judge. She seems like everyone else, not to remember I am innocent until judged otherwise. She treats me as, I think I read this. I'm so sorry, guys. Just bear with me because this is my first time going through it. Okay. After my introduction and explanation with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. See, again, Sarah, just like Daryl and many other of these horrible people, they have to be in control, and they want to tell the other people how it's supposed to be, when again, they know nothing about the law. Just like Daryl, let's see, that went well for him, didn't it? Oh my gosh. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be respected no matter the outcome. Oh my gosh. Okay, outcome. There we go. I am innocent until adjudged otherwise. My attorney, everyone should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. How about you? How about how you treat the people who are trying to tell you what to do? Sarah does not want to reciprocate any of this stuff she is expecting of everyone else. I should feel secure, highly confident, proud in her representing my life. Well, I'm telling you, I told you, Miss Cashman already put in her letter, so this is all probably a moot point at this time and date. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her What kind of attitude is she saying there? I am so sorry. I cannot read that word. Okay, I'm sure it's a negative thing. Attitude towards me. I am hoping by this letter she will pick up the sword of justice and fight alongside. What? We are not thinking of those old, that old show, Xena, Princess Warrior, or Warrior Princess. This is not, no, she doesn't need to pick up any sword. I know she's meaning it. She doesn't mean it that way, but still. Alongside, not against me, or so many unmotivated, overwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessful. See? She's sitting there. Wow. Okay, so I started this letter. Of course, it was late and I was tired. 10:30 Friday night, because I think that's when it was received. So I really wanted to get it done and post it. But I got to tell you, I read what I did, and then I kind of read a little bit ahead, and there were so many pages left, my eyes glazed over. I was exhausted, so I said, okay, I will finish it yesterday. Today is Sunday. Well, like I said, I'm with family, which I'm very much enjoying. But I got up yesterday at 5, went kayaking over on the East Coast, which that was amazing. So by the time I got home, obviously I was tired, and so now I am here Sunday morning back as we try to go through this painful journey together. This is close to where I left off. So we're at the top of this page. So it's my case equals bizarre, unknown, different, ignorance, misunderstood, unfair. This does not mean my case can't equals success, and in more than one way. Well, everyone continues to ring their bells of malevolence. Oh yeah, I guess that means malicious or whatever. Just say malicious. I am ringing mine of hope, honor, plausibility, boldness. Listen. I am not a murderer. The justice system should equals fair, faith, trust, respect, innocent until and if adjudged otherwise. 3-point back. Oh, for the love. And then Sarah Boone. Does that mean that that's concluded? And then she writes, confused cat meme. Yes, thank you. Oh, for really, very middle school. Okay, so now this starts something else, because that was like 8 or 9 pages, something like that. What is this? This says June 4th, 2024, video visit 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/24 at my status hearing, today my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in 2 letters. Oh, poor Patricia. Dated 5/20/5/25. All on the public video visitation box were on both sides of me, less than 5 inches away from my visit. Other inmates were having their visits also. Oh my goodness. Right there. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box, where there is no privacy whatsoever, and hold in an open bay dorm with more than 62 other interested, all ears inmates. Well, maybe they're not interested. Maybe the other people are interested in discussing their cases or seeing their family members or whomever you get to see. Don't flatter yourself that much, Sarah. Right up there. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorneys, looks like she's saying, no, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me. I can listen or not, still going, over speaking, and not at all allowing me to respond. Oh, jeez. After repeating to her over and over and over, while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard, I disconnected the visit telephonically. She uncooperatively. She is impossible. See previous letter or ask her for a copy of the 2 I sent her. I don't think anybody wants any more of your damn letters, Sarah. Let's see, 2 I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. Why does she keep trying to bring the pulpit to it? That sounds like, I always, when I think of pulpit, I think of like a pastor at the pulpit, in church. So I don't know why is she bringing that into it. I mean, you do need Jesus and a lot of prayers, that's for sure. My question, please, who acts like that and still be able to call themselves professional? Oh, gosh. there. The visitation box is primarily for family and friends to connect. And if is it requests? I'm not sure, from an attorney, reminders, notices, quick questions, not high-level confidential care case information. She, like other former attorneys who always blame their dysfunctions on me, said, oh boy, she's throwing all the attorneys under the bus. You don't like the answers I gave you? What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid. What? I've been doing this for over 40 years. Professional, after so long, and all the experience, common courtesy, customer service, and listening skills should have been acquired. Well, I honestly don't think Sarah is a good listener, because just look at this. All attorneys, do you remember why you even wanted to be one? Remind yourself. Well, now she's throwing all attorneys under the bus. See, she's really insulted the attorneys. Actually, the whole world. Because everybody is idiotic and they're uninformed and blah, blah, blah. She wants the attorney, probably Patricia was like over it when Sarah started talking about the pretend judge and picking up alongside her the sword of injustice to fight with her. Good Lord. No one listens, and it works in everyone's favor but mine. That I, a murderer, stuck in jail so they can pin on me their uninterested, unmotivated, hopeless, they're going to be leave me over her haughty attitude. I'm not wrong for not thinking less of myself, because everyone else has and does. This present attorney foremost. Okay, yep. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the unit attorneys that keep aimlessly throwing darts for and what? Appointing? Praying they don't withdraw. Well, please, what do you expect? Oh dear, sorry, I bumped it. She's getting me all worked up here. Okay, oh, here comes the big letters. I have not fired any attorneys appointed in my case. For me expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous, mismanaged case, and representing myself is not an option. Oh, okay. As both judges have now threatened me with, from being outspoken and intelligent. I bet you they didn't say intelligent. I bet they just said outspoken. In all my observations of the ongoing abuse. My gosh. What about George's abuse? There. I am and have experienced. I have no experiences from it always being the same. Blame Boone. Blame Boone. Okay, we'll call her Blame Boone. Sarah Blame Boone. Okay. Now, you wouldn't know this unless I told you all of this, of course. But I'm kind of giving you, I'm kind of enjoying giving you all the blow-by-blow account of how I'm trying to get this recorded. So this is attempt 3 to complete this very long Sarah Boone letter. So the last time you heard from me is around 9 o'clock this morning. Now it's around 9:30 tonight, Sunday night, as I attempt to get this Boone letter read But what was funny, I was out here, well, to explain, I have a little micro camper that I keep at my son's house. He lives in North Florida. And so when I come to visit, I just stay in my little micro camper because his property, he's got a little bit of property. It's kind of out in the country. So it's just kind of like, camping, but easy camping, But so I was in here this morning trying to get some done. And suddenly, in the middle of me reading the letter, I mean, I could leave it in, but it would sound ridiculous. He thumps on the door, and I'm like, "What?" Right in the middle of, I think I was like, after blame Boone right there, and then it's something like, I refuse to, and then it was like, bang, 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 and I'm like, "What?" And then so he called me in, and I never got back out until tonight. And just FYI, totally non-related to anything, but we have been binge watching, and I thought it was just a movie. On Netflix, it's Your Honor with Bryan Cranston. And if y'all haven't seen it, it is wild. It has messed with my mind. I mean, whoever wrote this, man, if it was one person, I don't know how they did it, because there are so many complex stories and situations and characters, and it is very, very good. But it is also very tense. There's a lot going on, a lot of stuff going on, but there's actually 2 seasons. Like I said, I thought, oh, it's a 2-hour movie. And then we're going, wait, it's 2 seasons? But like, you're addicted to it. So I'm so happy to be out here now, even looking at Sarah's letter as a nice break from all of that stuff. Because like I said, it is a lot. But if y'all haven't seen it, I would highly recommend it. I think it's excellent. And I haven't quite finished it yet. We are on season 2. But I mean, we have definitely had a marathon, which I have enjoyed, because time with family always comes first, and it's always fun. But let's have fun with Sarah. Okay, so yes, it was right after the blame Boone part. And so she is now saying, I refused to be what? She refuses to what? To be moved and wanting respect. That doesn't even make sense. I probably didn't say that word right. I just can't read her writing. Refuse to be something and wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. Oh my gosh. Oops. So she didn't want to represent herself. I don't know. I mean, I know they're threatening her, but if she's going to keep, running attorneys off, I don't know what option she has. Plea out. And another great reason not to have my case meetings on the public visitation box is my personal, confidential inmate information, such as my visitation list, 2020 through 2023, with names, etc., my interactions with inmates and officers. Oh gosh. Okay. Whatever you say, Sarah. Okay. Oh, I guess it also records saying here, when I eat, when, and my personal jail calls also being thrown online. For what? I hate no more or try to get others to because I don't eat breakfast, or because I know some Latin, have short hair, my penmanship is nice. What the hell are you talking about? Or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate I don't know what that says. I want to say reiterate, but I'm not sure. I'm sorry. Just pause it and look at the letter, because I'm just like, splice, edit. The world apparently knows all. Well, of course we do. All of these things you're writing is public. and I am reading it. I am one of many people who was reading it right now. It's public knowledge. So I don't know what your deal is. Anyhow, right there. What's next? How many times I go to the bathroom and what function I perform? Well, you know what? While you're writing this letter, you might as well let us know. How many times did you urinate? How many times did you defecate? Did you have to strain? Was it diarrhea? I don't know. That's, you know what, Sarah? Nobody cares. No one knows anything nor seems to want to from being comfortable in their corruption and striving to be on top with ratings. Well, I'm not really striving to be on top. I'm just like enjoying sharing this information. With ratings, web hits, and money, my case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted and poked fun at about me, it's all in my favor, proving myself right about all the mindless Lennings. What is she saying? Sorry. Is it shut-ins? The justice system advantageously abusing and prorating from everything in my cases before my trial and before I've seen. Please be sure to read my attachment for, oh my gosh, she's got so many attachments, for FRCP rule, blah, blah, blah. Letter E, restricting disclosure. Am I the only one who thinks of these things? Clearly, because you have time to think of these things. When can I win in anything? It's coming. I am not the problem, and if anyone were to slip, oh my God, on my slides, see, I'm really getting tired of that. Yes, we know that you wear slides in prison. We're well aware. And it's, you know, it's like instead of take a walk, you know, have a walk on my shoes, it's the slide thing. It's getting very old, Sarah. And have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. Oh my gosh, I think I've already read this. I sure did. Don't knock it if you try it. 3-point back, race to the pulpit. Again, always, Sarah Boone. Did I, or am I reading? Wait a minute. What? I hope, if I did read it. Oh, so this is West Florida statutes annotated. Florida Rules of Criminal Procedure 3.2206 discovery. A, notice of discovery. After the filing of the charging document, a defendant may elect to participate in the discovery process provided by these rules, including the taking of discovery depositions by filing with the court and serving on the prosecuting attorney a notice of discovery which shall bind both the prosecution and defendants to all discovery procedures contained in these rules. Oh my gosh, I don't know how much we want to read of this jargon, but let's look. We'll keep on looking. Okay, prosecutor's discovery obligation. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to inspect, copy, text, and photograph the following information and material within the state's possession or control. Oh my gosh, okay. So we're there. A list of names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact evidence to be presented at trial under Section 90.40412 Florida statutes. Oh gosh. Okay. The statements of any person whose name is furnished in compliance with preceding subdivision. The term statement or used herein includes a written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. The term statement is specifically intended to include all police and investigative reports of any kind prepared for in connection with the care, but shall not include the notes from those reports are compiled, from which those reports are compiled. C says, any written or recorded statements and the substance of any oral statements made by the defendant, including a copy of any statements contained in police reports or report summaries, together with the name and address of each witness to the statements. Any written or recorded statements and the substance of any oral statements by a co-defendant. These portions of recorded grand jury minutes that contain testimony of the defendant. Okay. F. Any tangible papers or objects that were obtained or belonged to the defendant. The suitcase, the cell phone. I wonder if they collected the paintings and the puzzles they did on that day that was such a good day as evidence. Okay, letter G. Whether the state has any material or information that has been provided by confidential informant. Ooh, H has a star by it. This must be really important. Okay, let's see. Oops. Sorry, I don't mean to make you dizzy here. Good Lord. Sarah, you're making me nuts. Okay, H. Oops, let me get it. So sorry. Hope I didn't make you dizzy. Sometimes this thing jumps. H. Whether there has been any electronic surveillance, including wiretapping of the premises of the defendant or of conversations to which the defendant was a party, and any documents relating thereto. I, down there, whether there has been any search or seizure and any documents relating thereto. J, reports or statements of experts made in connection with a particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. Okay. K says down there, any tangible paper or objects that the prosecuting attorney intends to use in the hearing or trial and that were not obtained from or that did not belong to defendant. Any tangible paper, objects, or substances in the possession of law enforcement that could be tested for DNA, and whether the state has any material or information that has been provided by an informant witness. 2 there, if the court determines in camera that any police or investigative report contains irrelevant, sensitive information interrelated with other crimes or criminal activities, and the disclosure of the contents of the police report may seriously impair law enforcement or jeopardize the investigation of those other crimes or activities, the court may prohibit or partially restrict the disclosure. 3, the court may prohibit the state from introducing into evidence any of the foregoing material not disclosed, so as to secure and maintain fairness in the just determination of the cause. 4, as soon as practicable after the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendants as to any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations. So is this something that so is the prosecution supposed to be turning stuff over to Sarah, or should that be to her attorney? I would think, correct? I don't know. I'm not a lawyer, of course. D, defendant's obligation. If a defendant elects to participate in discovery, either through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, the following disclosure shall be made. Oh my gosh, shall I lose it? Here we go. Oh my gosh, I keep moving it and then it goes the wrong way, which where I've already been. Okay. If I've read this already, I'm so sorry. Within 15 days after receipt by the defendant of the discovery exhibit furnished by the prosecutor, pursuant to subdivision of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as witnesses at the trial or hearing when the prosecutor subpoenas a witness whose name have been furnished by the defendant. Except for trial subpoenas, the rules applicable to the taking of depositions shall still apply. B, within 15 days after receipt of the prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit which shall disclose to and permit the prosecutor to inspect, copy, text, and photograph the following information and material that is in the defendant's possession or control. I, the statement of any person listed in subdivision other than that of the defendant. Reports or statements of experts that the defendant intends to use as a witness at a trial or hearing made in connection with a particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons, and any tangible papers or objects that the defendant intends to use in the hearing or trial. The prosecutor and the defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. Okay. 3. The filing of a motion for protective order by the prosecutor will automatically stay the times provided for in this subdivision. If a protective order is granted, the defendant may, within 2 days thereafter or at any time before the prosecutor furnishes the information or material that is subject of the motion for protective order, withdraw the defendant's notice of discovery and not be required to furnish reciprocal discovery. Okay, I don't know how much more I want to read or what you all want me to read. This is a lot of like legal stuff she's apparently copied down from a law book or a law dictionary or something. And I don't know how much is this pertinent. We could just skim through. What I recommend you all do, if they haven't already put it up, is go to Lawyer You Know, or Southern Law, or both, because they are always both really good at breaking down this legal mumbo jumbo that I do not understand. I'm just giving you what is here. Okay, so let's see. It's talking about additional discovery and sanctions. So basically, she's copying all this down and telling them, what they should be doing. But I don't know how this goes. I mean, it sounds like she really does need to represent herself, even though she says she doesn't want to, because she doesn't like the way anybody's telling her how to do it. She doesn't want to listen. She thinks she's smarter than everyone. Okay. Every request for discovery or response or objection, including a notice of deposition made by a party. This is a lot of stuff. And, like I said, you can actually pull this up, of course, on the Orange County, Florida website and read it for yourself. But it's kind of a pain. And a party who is not represented by an attorney, I'm going to read this part here. Let's see. A party who is not represented by an attorney must sign the request, response, or objection and list his or her address. The signature of the attorney constitutes a certification that the document complies with Florida rule of general practice and of judicial administration. The signature of the attorney or party constitutes a certification that the signer has read the request. Okay. But so far she has been represented by an attorney. Oh my goodness. Okay, A, it says consistent with these rules and warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. This stuff, it means nothing to me. I don't quite understand it. I think she's just writing down everything that they already know. Well, let's see what it says here about willful violation. Willful violation by counsel or a party not represented by counsel of an applicable discovery rule or an order issued pursuant thereto shall subject counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings against the attorney or unrepresented party as well as the assessment of costs incurred by the opposing party when appropriate. Oh my gosh. Every request for discovery or response or objection, including a notice of deposition made by a party represented by an attorney, must be signed by at least one attorney of record. It's defined by Florida rule of blah, 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 blah. This is a lot. A party who is not represented by an attorney, but so far she has been represented by an attorney, so I'm not sure what that means, honestly. Consistent with these rules. Okay, let's see what the pre-trial conference says. This might be good. Okay, so pre-trial conference. The trial court may hold one or more pre-trial conferences to consider such matter as will promote a fair and expedient. I can't even talk. The words I normally pronounce, I can pronounce, but a speedy trial. How about that? The defendant must be present at any pre-trial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. So that might be part of a problem. You know, her big thing about wanting to be included. And so it's saying the defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. So maybe there's times she feels she hasn't been included, but maybe she didn't need to be there. Sometimes that's the case, but I guess we'll find out. It says the court may set, and upon the request of, oops, hang on. Okay. The court may set, upon the request of any party, must set a discovery schedule, including a discovery cutoff date at the pre-trial conference. Okay. I'm going to just skim over this. That the individual shall have full protection in person and in property is a principle as old as common law, but it has been found necessary from time to define, oh my God, the exact nature, excellence of such protection. Political, social, and economic changes entail the recognition of new heights and the common law in eternal youth grows to meet the demands of society. Dear Lord. There, in very early times, the law gave remedy only for physical interferences, blah, blah, blah. Okay. This is like she's like doing a book report. Remember, like if you, in PE back in the day, if you missed, you were supposed to like write a 5-page report. This is kind of like what sounds like she's doing. She's looking at for something out of the law dictionary. It's just all these things that American Declaration of Independence. Okay, we got that. She's going to talk, it looks like she's going to talk about the Florida Constitution. Oh, now she's going to do like a vocabulary list, a glossary. Client, a person who relies on the professional services of another. The client of an attorney is the person or entity represented and advised. Get that, Sarah? Advised by the attorney. by the attorney, not to be told what to do and how they should do it and when by the client. It's by the attorney. A client relationship commences for an attorney with an agreement with the performance of service and reliance on a request for representation, or with a statement of representation on which the client relies. Well, you know, she's trying to do it. You just needed to listen to Patricia, for the love of God. All attorneys owe a client a duty of zealous representation balanced by the obligation to serve justice and act as an officer of the court. Well, of course, just because you think she's snippy doesn't mean she still won't do a good job. My question would be, Sarah, do you want someone who's nice, or do you want someone who's going to win the case for you? Because you know what? Patricia probably is a bulldog and probably would have fought for you, but not now. You lost that one. Oh, wait a minute. Attorneys are also to keep the confidence of a client. Oh, okay. This is what she's talking about. The what is it? The 12-minute video conference, and perhaps Patricia didn't do it properly by speaking to her where everybody could hear, and probably no one was interested. Attorneys also have an obligation to keep the confidence of a client at all times, and to keep the client informed of all matters related to the client's interests, to inform the client of law related to the client's affairs, and to defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibilities and to the law. See right there? That right there, I'd highlight that one for Sarah. She wants everything from them. And yes, they are technically, just like when we go to the doctor as a patient, in a way the doctor is they are our employer. No. Yeah, we are their employer, and they are our employee as patients. We are the employer. But okay, so yes. And to defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility and to the law. Right there, to me, says a lot. Attorney-client privilege. One of the oldest recognized privileges for honest, equitable, confidential communications, intended to encourage open, full, and frank communication between attorneys and their clients, hereby promoting broader, confident correspondence in accordance to the appropriate observance of law and the administration of justice. Zealous advocacy. Yes, we already read that one. Okay. You know, zealous doesn't always mean... Oh my gosh. Where did zealous go? There we go. Zealous advocacy. An attorney must represent each client to the fullest extent under the law and requires representation to the attorney's fullest abilities without violating the rules. Didn't we already read this, or is this being redundant? Maybe not. I think it's being redundant, though. But just in case, I'll read it. Professional responsibility. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefit the client while remaining faithful to the facts and to the law itself. Oh, there's zealous again. Zealous advocacy is a requirement of the oaths required by attorneys admitted to the success of the adversion system of justice. Disruptive, disrespectful, degrading, or any disparaging rhetoric is never an inclusion of zealous advocacy, and the use of such crosses the line from acceptable forceful advocacy into unethical conduct. Boy, she is really slamming Patricia Cashman. I don't blame her at all. She has every reason to not want to do it. I really hope that the judge does not make her do it. Here we go. Attorney misconduct is a failure of an attorney to comport with the rules and accepted professional customs of the law. Is that bar or law? I'm going to say of the law bar, and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer to the court, as a counselor and fiduciary of a client, or as a member of the legal profession. The scope of attorney misconduct reaches also to conduct of attorneys that is harmful to the appropriate reliance of the citizenry upon the law and legal profession. I mean, where does Snippy fit in here? Attorney misconduct includes actions or omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or to sanctions, although a variety of forms of each exist. Boy, oh, Sarah, for the love. Right there. Misconduct may always be the basic for a client to remove an attorney from their duty of representation, as is any other cause for the client's loss of trust and confidence in a lawyer. The attorney's demeanor to determine whether a party's substantial rights were affected, based on repeated or persisted objected to misconduct. The district court shall factor into its analysis that the notion by engaging in continued misconduct, the offending attorney has accepted the risk that the client's case may be influenced by said misconduct. I don't know if there's any misconduct at Sarah. Therefore, the district court shall give great weight to the fact that single instances of improper conduct that could have been cured by objection and admonishment might not be curable when that improper conduct is repeated or persistent. And then it's from this law, something. Duress. Oh dear. Hang on a minute. So, duress. And I don't know how much longer I'm going to go. I might skim through this because this is all just stuff apparently she has, excuse me, has gone through all these different law books, dictionaries, and copied stuff down as if the lawyer and judge don't already know all of this. But I guess she's making a point. But let's check out duress, because I'm sure that's how Sarah feels, that she's under duress. And excuse me, guys, my allergies getting me. An unlawful threat that limits the person's independence of judgment or action and is any improper threat or condition such as coercion, I can't, coercion, say it 3 times fast, that limits a person's ability to think or act independently and the presence of destroys the independence required of the party subject to in order to constitute a voluntary consent, it must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose right is involved. In addition, such person must be cognizant of their rights in the perimeter. The consent must not be contaminated by any duress of coercion, and the government has the burden of proof. Lord have mercy. And see, now it's just getting into more of this legal stuff. I mean, this is just a little bit of this here, I guess I could do. Excuse me. An attorney or other professional has an obligation to provide any person with adequate information and explanation of a proposed course of action and its alternatives for the person to know of the material risks of each before consenting. By definition, professionals and fiduciaries have similar obligations to their clients and to those with a reasonable right to rely on their information or advice before consenting. The lawyer or other professional shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is defined in rule, blah, 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 yada, yada, yada. All this stuff is what she's trying to say. Keep the client informed. She wants to be included. I mean, all this is the same stuff that she's complaining about. And what gets me, though, is all she keeps talking about is her rights and what everyone's duty is to treat her properly. And what about how she treats the judges, the attorneys, everyone else? I mean, there's got to be something in there too that the client has to behave themselves. Legal ethics, yes. I just feel like we can just go on and on and on. Abusive process. Interrogation. Excited utterance. Oh, what the heck is this? let's see, it's a map. Of course, it's publicly exploitation and saturation. What the heck? What is this about? Okay, let's see what this is about. This has got to be good, I'm sure. Okay. I can get it to move down. So to date, each star is a state where I have received correspondence via mail or message regarding my current criminal case. Okay, so let's look for the freaking stars. Oh, okay. So what? Okay, I'm looking lopsided. There's Florida, Georgia, South Carolina, North Carolina, Virginia, Texas, Louisiana, South Dakota, Minnesota, Wisconsin, Michigan, Indiana. Okay. Up over in the New England area, like is it Vermont, Maine? It's tiny up there, New Jersey. Okay, so what's the point? Okay, haven't read all of them, but obviously she's received correspondence from a number of states. Oh, and there's countries too. There. I think, honestly, I don't look. She can sit there and complain, but trust me, she is enjoying the attention no matter what she wants to say. So I didn't cover it all, but you can see stars. Regarding her criminal case, the number grows daily. Most all letters and messages are available for review and understanding of the impact of my case. Details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. Probably all these people saw George flopping around in the suitcase like a mackerel, and I don't mean that disrespectfully, but it's horrible. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. How does she know this? How do you know this, Sarah? Oh, for the love of God, Sarah. Okay, wait a minute. This could be a little bit interesting, I suppose. I lost the map, though. Oh, there it is. Good gosh. You know what? More than anything, you're exploiting yourself by all these letters. You're drawing more attention. The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair, saying theorize or whatever, theory, okay, ideas, accusations, forcibly insinuating I committed criminal acts. Well, you did. My current attorney said it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unavailable to be located to date. I am missing innumerable case items which I continuously request to be returned or obtained without success. Invasion of privacy. Oh boy, Supreme Court wrongful conduct. Okay, so she's just naming all the invasion of privacy crap. Defame. Yeah, we know what all of this means, Sarah. Invasion of privacy. The line is drawn when the publicity ceases to be the giving of information to which the public is entitled and becomes a morbid, sensational prying. Yep. I'll tell you what's morbid is what you did to George. Publicity, exploitation, and saturation. Okay, we this is all redundant. We really are going in circular. This is very circular. Trickery, duress, confusion. Oh my gosh. Invasion of her privacy. I don't really understand. Before her rightful trial. This is all the same stuff. I'm just sorry. Now she's listing off the vocabulary, which will all be quizzed on later. Due process, yes. These are all... Oh, look at that. It's like, all be tested on this vocabulary. I already saw excited utterance, too. Coercion, we saw that. Oh, that is actually the end. Look, I think I even read a lot more than we probably needed to. And if it's boring to you, you can skip through it. I was just trying to pick things that were crap that she had already said. But really, what she's doing is she's really just throwing everybody under the bus, not just the current attorney, but all the other attorneys. And yet she claims that this is not her fault, and that, like she said in court about Patricia Cashman, she says, I don't want her to go, but I want her to do it all my way, and she's already, I know she even said she sent some letters to Patricia Cashman, and perhaps it was the condensed version of all of this. All this stuff Patricia knows, and yes, the client does have a right to a point, but she needs to shut up and listen to what they're trying to tell her. I mean, in the end, I don't care who she gets. I don't know how that she will be found innocent with all the overwhelming evidence. But of course, she deserves a fair trial, but she cannot be, and she says she's not, but she is. She's criticizing everyone, everything. Everything is everyone's fault but hers. She's not taking responsibility for anything. She hasn't taken responsibility for George. Why should she for all of this? She's just, everything she says that people, I can include myself, me, are accusing her of, though, is true by her actions and all of these letters. It just makes it even more visible. I think she's doing more harm to herself than anything that the media could be doing to her. Because she's putting out all of this stuff, all of these complaints. And no, I don't believe 8 attorneys that it's their fault and not Sarah's. I'm not saying some of them maybe aren't great, but come on. Number 9 isn't going to work. And she doesn't want to represent herself, but yet she still wants to tell everyone how to do it and be in control of everything. She's clearly, as we all have seen, a control freak. So this is crazy. It will be interesting. I wonder if they'll have a hearing soon. Oh my goodness. But I think I showed you, you probably saw a lot more than what you even wanted or needed to see. But I was just trying to highlight some of the places where she's obviously made complaints. But I don't think everybody needed a big glossary of, all of that stuff. She still could have kept it to at the most 5 pages. That would have been plenty good. They didn't have to have all this stuff spelled out to them, stuff that they already know, and most of us do. Okay, but that's it. I'm done with Sarah for today. And hopefully, and it's Monday morning, by the way, just to give you a blow by blow. So I had to finish it up, and hopefully it will be out to you all later today. And we will continue on with the saga of Suitcase Sarah. All right. Thanks for hanging in here with me with this. This is crazy. But thanks so much for watching, commenting, subscribing. I love you all, and I really appreciate you all hanging in there with me. Be kind to everyone. Be kind to you. And I'll see you the next time.
The reason why I'm here is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.